Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and make sure you hit that little bell for notifications so you get notice of when we go live or put up new content. You may be saying, Scott, why are you going live on a Friday afternoon shortly after 3 o'clock? Well, a couple of things have happened. Scheduling issues, and Frank, the hardest working man in show business, well, he's not here. He took a day off. Can you believe it? Who takes a day off on a Friday right before the holidays? Really? Anyway, no, he deserves it. Good. He's a good man, and he had some stuff to take care of. Anyway, so we're going to do the show. We're going to do it live, and then tell all your friends, share it with everybody. All right? Now, what are we going to talk about today? We've got a couple of things. Well, there's been a report that indicates, guess what? Schizophrenia, a schizophrenia diagnosis for Nick Reiner. Obviously, that's going to affect his case huge, if that is in fact the case. We're going to talk about the Wisconsin judge that got convicted of a felony obstruction in an immigration enforcement case. And guess what? She's probably going to prison. We've got this day in legal history, the quote of the day, and our dumb criminal. So let's start talking about it. All right, everybody. First off, it is December 19th, 2025, and let's get to the docket. All right. First, the report that there was a prior schizophrenia diagnosis for Nick Reiner in connection with the death of his parents. All right. So new details have emerged regarding the mental health history of Nick Reiner, the 32-year-old son of acclaimed filmmaker Rob Reiner and Michelle Singer Reiner, who obviously has been charged with their murders. Now, according to multiple sources cited in recent media reports, Nick Reiner had been diagnosed with schizophrenia prior to the fatal stabbing of his parents on December 14th of this year. Now, reports suggest that Reiner was receiving psychiatric treatment for the condition, and his behavior had reportedly become increasingly concerning in the weeks preceding the incident. Now, sources also indicate that a medication adjustment approximately 1 month earlier may have contributed to the heightened instability, with descriptions of Reiner appearing disoriented during this period. Now, efforts were reportedly underway to refine his treatment and for better stabilization of that time. All right. Now, additionally, Reiner had recently completed treatment for at a specialized facility in Los Angeles, addressing both mental health issues as well as substance use and substance abuse, is noted to potentially exacerbate symptoms of schizophrenia. Now, schizophrenia, as outlined in the Diagnostic and Statistical Manual for Mental Disorders, DSM-4 manual, this is over up to the 5th edition, and that is published by the American Psychiatric Association, is a serious mental disorder requiring at least 2 of the following characteristic symptoms for a significant portion of 1 month or less if successfully treated. First, delusions, hallucinations, disorganized speech, grossly disorganized or catatonic behavior, or negative symptoms such as diminished emotional expression or avulsion. At least one of these must be delusions, hallucinations, or disorganized speech. Now, for a full diagnosis, signs of the disorder must persist for at least 6 months, including at least 1 month of active symptoms, and must cause significant impairment in social, occupational, or other important areas of functioning. Other potential causes, such as substance use or mental conditions, must be ruled out. Now, the DSM-5 eliminated previous subtypes of schizophrenia, focusing instead on a dimensional approach to symptoms severity. Now, Reiner, who resided in a guest house on his parents' Brentwood property, faces 2 counts of first-degree murder with special circumstances alleging multiple murders and of the use of a deadly weapon. Now, he is anticipated to enter a plea of not guilty by reason of insanity. I certainly would anticipate that, particularly in light of this apparent schizophrenia diagnosis. Obviously, Reiner has a documented history of substance use challenges and prior rehabilitation efforts. He had gone to rehab 17 times over the last 15 years. So clearly there were some underlying issues, more than likely self-medicating, what have you. But if this is in fact the case, if there's a diagnosis, guess what? He's got a not guilty by reason of insanity straight face defense that can be used in his case. So maybe if it's in fact the family's goal, the rest of his days in a mental health institution and not in prison. Now, for those who may be not familiar with it, Rob Reiner, he was 78. His wife, Michelle Singer Reiner, she was 70, and they were discovered at their home by their daughter, and the Los Angeles County Medical Examiner determined and confirmed death due to multiple sharp force injuries, and it was ruled a homicide. Reiner was arrested shortly after the incident and appeared in court earlier this week, where the arraignment was scheduled on January 7th of next month. And his attorney has described the case as complex and urged restraint in public judgment. So like I said, I think there's going to be a mental health defense coming on here. So how does this affect the not guilty by reason of insanity plea under California law? Well, in California, the defense of not guilty by reason of insanity, or NGRI, is governed by Penal Code Section 25B, which adheres to the McNaughton rule. Under this standard, a defendant is considered legally insane if, due to a mental disease or defect, they were incapable of knowing or understanding, appreciating the nature and quality of their act, or of distinguishing right from wrong at the time of the offense. The burden of proof rests on the defendant to establish this by a preponderance of the evidence standard. Now, a diagnosis of schizophrenia can potentially support an NGRI plea, as the disorder frequently involves delusions or hallucinations and may impair a person's ability to comprehend the nature of their actions or recognize their moral wrongfulness. For instance, if psychotic symptoms such as command hallucinations or delusional beliefs directly influenced the criminal act, expert testimony would have to demonstrate that the defendant met the McNaughton criteria. However, a schizophrenia diagnosis alone is insufficient. The defense must prove a direct causal link between the mental illness and the incapacity at the precise moment of the crime. Substance abuse, if present, well, that's going to complicate the plea, as voluntary intoxication or related disorders cannot solely form the basis of the insanity under the California Penal Code, Section 29.8. The plea would be bifurcated. Guilt is determined first, following a separate phase on insanity if necessary. Now, success rates for NGRI pleas are low, involved in fewer than 1% of felony cases nationwide, and succeeding, well, it's approximately 25% of those 1%. If successful, the defendant would be committed to the state hospital for treatment rather than prison, with confinement potentially lasting longer than a standard sentence. Now, obviously, if the possible penalty is life without the possibility of parole, you can stay at the mental institution until you die of natural causes, or however you die. So that's something that they have to consider as well, but clearly mental health institution would be better than prison. Anyway, obviously, these outcomes need to focus on public safety and mental health treatment, but we'll see how far it gets. Anyway, we will continue to follow this. If that is in fact the truth, that there is a diagnosis, guess what? Alan Jackson just got himself a defense, a straight-face defense, and he may be able to get the district attorney to possibly agree with him that Nick Reiner was in fact NGRI. We've had this, I've only done a couple of NGRI cases because frankly, they're not that common. We had one not too long ago where, hypothetically, let's say somebody went to the office and, started stabbing all their coworkers. Didn't think we were going to be able to do much of it. Got a great doctor who's very good, very straightforward. And he said, yeah, this guy, was basically schizophrenic in a period of psychosis, gave the report, entered an NGRI plea. DAs looked at it. They sent their own expert down. They agreed we did a stipulated NGRI sentence. It can happen, not all the time. Usually the prosecution thinks that somebody's faking it and that nobody has any sort of disease, or if they do, we'll just fix them up and then we'll try them. So we'll see if they move forward with a competency evaluation. It'll depend on if Mr. Reiner is in fact suffering from schizophrenia, and two, if they get his meds worked out, if he's in fact taking meds to control his schizophrenia. Next on the docket, a Wisconsin judge, she got convicted of felony obstruction in federal court. And that's not good, ladies and gentlemen. So a federal jury has convicted Milwaukee County Circuit Court Judge Hannah Dugan of felony obstruction of federal proceedings following allegations that she interfered with U.S. Immigration and Customs Enforcement, ICE agents. Well, they were there attempting to arrest an illegal in their courthouse earlier that year. Now, the conviction came down yesterday after a 4-day trial and approximately 6 hours of deliberations. This stems from an incident back on April 18th of this year, where Eduardo Flores Ruiz, a Mexican national facing misdemeanor domestic battery charges, appeared in Judge Dugan's courtroom. Federal agents acting on an administrative immigration warrant were positioned in the hallway to apprehend him upon conclusion of the hearing. Prosecutors alleged that Judge Dugan, upon learning of the agents' presence, confronted them, questioned the validity of the warrant, and then directed them to the chief judge. Simultaneously, she reportedly expedited Flores Rios' hearing and expedited the hearing, then instructed him and his attorney to exit through a non-public jury door. Now, although Flores Ruiz was ultimately arrested outside the courthouse after a brief chase, they ultimately got him, and then he was subsequently deported. The actions were deemed intentional interference with federal immigration enforcement, and the jury found Judge Dugan guilty on the felony count of obstruction or impeding proceedings before the United States department or agency, which carries a maximum penalty of 5 years in prison. She was acquitted on a separate misdemeanor charge of concealing a person from arrest. Now, the Deputy Attorney General, Todd Blanche, described the verdict as a reaffirmation that nobody is above the law, emphasizing the Department of Justice's commitment to enforce federal immigration statute without exception for public officials. Defense attorneys maintain that Judge Dugan's conduct reflected confusion amid evolving courthouse policies on immigration arrests rather than deliberate obstruction, and they argued that she exercised legitimate judicial authority in managing courtroom procedures. Now, following the verdict, the defense indicated plans to file a motion to challenge the conviction, asserting opportunities to demonstrate her innocence. Now, she did not testify to explain her confusion, worth noting. Now, obviously, she never has to testify. She never is forced to testify in the legal system, and obviously she knows that. She's a judge. Anyway, obviously this case has drawn a lot of national attention because federal immigration enforcement efforts are obviously ongoing, and prior policies generally restricted courthouse arrests, but changes implemented during previous administrations expanded agents' authority. Obviously, some advocacy groups have raised concerns over potential impact on judicial independence and access to justice, while supporters of the prosecution view it as, holding people accountable for their interference for federal law operations. Now, Judge Dugan, who has served on the bench for 9 years, was suspended following her indictment. And under the Wisconsin Constitution, a felony conviction renders an individual ineligible to hold judicial office with a felony. A sentencing date has not yet been scheduled. Now, this prosecution is somewhat of a rare instance of federal charges against a sitting state judge. Usually those kind of things come down when they're alleging corruption, not necessarily this. So what does this really mean? I was looking online and people are like, well, she's going to get probation with a suspended sentence. Oh, no, my friends. She hit the big time. This is federal court. Probation is rarely given. I'm not saying impossible, but rarely given. All right. I'll give you an example at the end of this when we're done talking about it. So like I said, she's convicted, one count of obstruction proceedings, and then you have to go to the United States federal sentencing guidelines, which is one phase of the sentencing process that the court needs to consider. Although they are advisory in nature, they're no longer mandatory. It is the first step that the judge will consider when trying to come up with the appropriate sentence. So the offense under 18 United States Code section 1505 is referenced in Appendix A of the federal sentencing guideline, referring to section 2J1.2, obstruction of justice. The base offense level is 14. Then they look at specific offense characteristics under 2J1.2b, and they may apply adjustments such as an increase of 3 levels if the offense resulted in substantial interference with the administration of justice. And that is defined to include the unnecessary expenditure of substantial government resources, or an 8-level increase if it involved the threat of physical injury, which not applicable here. And in this case, involving interference with an immigration enforcement action that led to a brief pursuit, but a successful arrest, a 3-level enhancement for substantial interference is plausible. Ultimately, that yields an offense level of 17. However, absent such enhancements, the level remains at 14, but we're probably looking at 17. So you have to look at her criminal history category. She's going to be a 0-point criminal history category under the federal sentencing guidelines because she's a first-time offender. So at a level 14, without any enhancements, she's looking at 15 to 21 months of imprisonment. She could possibly get a split sentence, which is halfway house and prison. And at an offense level 17, she's looking at 24 to 30 months. And that's a zone D under the federal sentencing guidelines because, that's always important as well. Guess what? That requires some form of imprisonment. So she's not going to get the adjustments for acceptance of responsibility because, well, she went to trial. And don't get me wrong, I don't think you should be given a trial tax for proceeding to trial. But you are under the federal sentencing guidelines. But these guidelines are advisory now, but it's the first step where the court looks at to see what is appropriate. And remember, the judge could always impose the maximum sentence, which would be 60 months or 5 years. Like I said, so the no sentencing date yet, but we'll bring it to you. But this clearly shows, ladies and gentlemen, that if you want to be a judge, you go to be a judge because you love the law, that you want to do justice and follow the law. And I hate to say it, but if you're a judge and you can't leave your politics at the courthouse door, being a judge is not for you. Your job is not to decide if this law is good and should be enforced or whether it's a bad law and you don't think it should be enforced. The bottom line is, ladies and gentlemen, that if you're going to be a judge, you follow the law. And you oftentimes have to enforce provisions of the law that you don't even like, but that's just what you have to do. All right, next on the docket today, this day in legal history, on December 19th, 1998, a divided U.S. House of Representatives voted to impeach President Bill Clinton on charges of lying under oath to a federal grand jury and obstruction of justice in regards to his relationship with Monica Lewinsky. Next, how about a quote of the day? This quote is in regards to plea negotiations. It comes from a case called Missouri v. Fry. It's a United States Supreme Court case, 2012. And it says, quote, 97% of federal convictions and 94% of state convictions are the result of guilty pleas, plea bargaining. It's not some adjunct to the criminal justice system. It is the criminal justice system. Now, that statement was authored by Justice Anthony Kennedy, underscoring the central role of plea bargains in a modern criminal era. Obviously, there's a prevalence and essential functions in resolving cases efficiently and providing parties with mutual advantages when conducted voluntarily. Now, remember, most people don't know this, but up until about 50 years ago, there really wasn't plea bargaining. You can plead guilty or you go to trial. But the court system was basically getting overrun. And so they started doing more plea bargainings, well, charge bargaining that kind of takes place. Still not so much in the federal system. Sure, you can plead guilty. Maybe they'll dismiss a bunch of counts, but a lot of that still gets factored in under the federal sentencing guidelines. So you have to be, realistic when you go to federal court, like Judge Dugan was, and well, she'll understand. She's probably going to prison for some period of time. She's going to get some form of confinement because whether she likes it or not, guess what? A jury has found her guilty. All right, next on the docket, our dumb criminal of the day. Now, in a bid to inject some thrill into his admittedly blah existence, a 30-year-old Iowa man opted for a rather exposed approach, literally flashing motorists on two busy interstates, according to police. Danon Ari from Belle Plains, Iowa, is accused of positioning himself behind his Chevy Impala on consecutive days back in October, pants down and shirt up to display his private parts to startle drivers. These would have been drivers on I-80 and I-380 near Iowa City. When confronted by deputies, Ari reportedly confessed, explained the antics proved the excitement sorely lacking in his routine life, though he fully acknowledged the acts were improper and likely offensive to passerbys. Now, with a prior criminal record, Ari was arrested on 2 counts of indecent exposure, briefly held on a $5,000 bond, before being handed over to state prison officials for an apparent probation violation from an earlier felony, that'd be felony parole violation. Anyway, moral of the story, ladies and gentlemen, when life feels dull, perhaps stick to skydiving or something like that. Well, at least you can keep your pants on. All right, ladies and gentlemen, thanks for watching. I know it's a little different show today, but hey, when Frank, the hardest working man in show business, takes a PTO day, we still get the job done around here. All right, thanks for watching. Hope you have a wonderful weekend. We'll see you next time. And remember, the Constitution matters.